Stay seated. Back on the record. Who are these from, Sarah? All of them? Okay. Okay.
Your Honor, having discussed the matter with Mr. Romero, I believe we have almost an agreement as to our suggestion for the next point in the process.
Okay, let me hear the almost agreement.
I've provided the court with 4 cases, I believe, and there's also reference to Rule of Criminal Procedure 3.410. Essentially, as I understand the case law, the rule was modified, and it is now discretionary with the court to ask the jury for further clarification of their inquiry pretty much on that level of request. There is a more recent case, Hazuri, H-A-Z-U-R-I versus State, where the request was for a generalized readback. The Supreme Court of Florida held that the court should have asked which portions of the testimony the jury wanted read back. McGirth, I think, M-C-G-I-R-T-H versus State, which is a 48 Southern 3rd 2010 case, I believe is probably the most descriptive. That's a Florida Supreme Court case as well, and there's a section in that discusses the trial court. In that case, the jury asked whether it could have a discussion with the court regarding the jury instruction on principles, and the court responded that it could not engage in a general discussion with the jury, but would be willing to address any specific question the jury might have. And I think that obviously it's within the court's discretion to do that, but I think that should be, at least at this point, the extent of any communication would simply be, ladies and gentlemen, if you have a more specific question, there's a possibility we can answer it, or something like that.
It sounds like an agreement. I think that a couple of cases, and I don't know that you have all of these.
Well, if you have some kind of an agreement, can you tell me what kind of response? I left a jury question in my chambers, but I can write out a response on a separate sheet of paper. It's not a problem.
It seems like those cases, including Haygood, the very recent Florida Supreme Court case about 3 months ago, Haygood versus State, 109 Southern 3rd 735. And Diaz, D-A-I-Z, it might have been cited by the State, 957 Southern 2nd 104. Diaz is significant to the extent that it references Perryman, P-E-R-R-I-M-A-N, Florida Supreme Court case out of 1999, 731 Southern 2nd 1243, that says that where there are questions of law, the court can get clarification on their confusion, and then can actually answer specific questions of law with a sort of straightforward, quick answer. So I think the step is, let's find out their clarification.
Okay, well, if you'll give me the wording of what you can agree on, of what to send back to the jury, I'll go ahead and send that to them, and then we'll wait to see how they respond. So what type of...
I'll suggest one.
Either that, or we could just work, if you give us 5 minutes, we could probably come up with a written one ourselves.
Do you have a sheet of paper?
Yes, Your Honor.
Okay. If you can agree to one, that's great, and if not, I'll try to help you word it.
Great. I was going to approach you. Did you get the State's cases?
I do have the State's cases. I do have Perryman. I do have Diaz. I do have... I don't have the one that's from 3 months ago. Haygood. Okay, while you're working on the wording, I will review the case.
May I just see the question for a moment?
You could. I have to go back and get it.
We're close enough. Thank you.
Okay.
And once again, I said a word and a phrase.
The court reporter read it back because I read it. You could come up here and June when
I
I read it.
remember it to be something like, can we get a clarification on the instruction of manslaughter?
Law of
Law of
manslaughter.
You could get it specifically if you'll ask, if you'll come up here and read what was read into the record if you would like.
Thank you, Your Honor.
On the law.
Maybe we will just take the word whether or not they asked for instruction or law.
June, it would be when I came back in here and I read the question, and we'll stop talking while you go back and look for it.
May we please have clarification on the instructions regarding mental?
Clarification regarding the mental instructions. Clarification. You just read everything, right? Yeah.
Since it's detailed.
What are you telling me to do?
If you have one, please submit it to the court.
Don't take my pen, that's all. I got other stuff written on.
Thank you, Your Honor, for the time, and it's fine as we approach, it's not my reapproach.
You might reapproach, you may. So, Mr. Zimmerman, the proposed answer to the, you heard the jury's question, correct?
Yes, sir.
Okay, the proposed answer that has been agreed upon by both your counsel and the state is as follows. The court cannot engage in general discussions, but may be able to address a specific question regarding clarification of the instructions regarding manslaughter. If you have a specific question, please submit it. Is that acceptable to you, sir?
Yes, sir.
Acceptable to the state?
Yes, sir.
Acceptable to counsel for the defense?
Yes, sir.
Thank you. I'll rewrite it so it's one handwriting instead of two, and we'll have you review it. You may be seated.
At that point, do you intend then to bring them into the courtroom or present it by written note?
I was just going to give it in writing to them so they can,
Acceptable but to us, Your Honor, to do it that way.
right. That way they can reread it over and over again instead of me just reading it once and just to make sure that I wrote it down correctly, the court cannot engage in the general discussions, but may be able to address a specific question regarding clarification of the instructions regarding manslaughter. If you have a specific question, please submit.
Yes, Your Honor.
Yes, sir.
Okay, this will be given by the deputies to the jurors. Just so you know, they have ordered dinner. If counsel wants to have an hour to go to dinner, you may do so.
Your Honor, if we may want to be on standby for 5 or 10 minutes because they may come right back with a question.
Okay, that's a good idea. We'll go ahead and do that. Let's be on standby for about 15 minutes in case they have a response to that. Court is in recess.